What do we need to take up?
We need to harmonize. We need to harmonize.
Mr. Christensen is now in the courtroom. Mr. Isabelle, if you'll please come around to the seal. Follow the directions of the deputy.
Step this way, sir. Stand on the top of the seal, face the judge, raise your right hand.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Please have a seat, watch your step, and I'll need you to speak up for the benefit of Madam Court Reporter who's recording these proceedings, sir.
Good morning, Mr. Isabelle. You have sat through this trial, right? And you've listened to all the proof along with us.
You got to speak up, Mr. Massey. Thank you.
You're welcome.
Try to get you an additional microphone.
You've heard all the proof along with us.
Yes, sir.
And even before that, we've gone over the proof that we expected to be shown in this case, even showing PowerPoints and those kind of things, so that we may make sure you were aware of all the discovery available. And after hearing the proof today, or this past week and yesterday, and knowing that you have a right to testify, that's an absolute constitutional right to testify, tell this jury whatever your side of the case may be. And no one can make that decision as I told you yesterday, nobody but you. And what you do is you can look to others for advice, like you look to us for advice, you're lawyers. And you talk with your family as well, right?
Yes, sir.
And after doing that, and after hearing the proof, have you made a decision as to whether or not you wish to testify? Have you made a decision?
Yes, sir.
What is that decision, please?
I wish to testify.
You do not wish to testify.
No, sir.
I have no other questions. Thank you.
Do you mind if I just, for the record, flesh out some other things? You've made a decision to not testify, and I'm certain that Mr. Massey and Ms. Fuchs have informed you that the jury will be informed that they can't hold that against you. You have the right to remain silent. Has anyone made any threats or promises to get you to not testify?
No, ma'am.
You're entering into this season, this session of not testifying. It's your choice and yours alone. And that you understand that no one can draw any inferences, meaning no one can assume what you would or would not have said just because you didn't testify. And that's basically what I'll tell the jury. They can't hold that against you. You understand? And you've had enough time, not only just this morning, because I know you spent some time with your lawyers this morning to discuss this issue. And you did yesterday, right? I need words.
Yes, ma'am.
And you don't need additional time to discuss this decision.
No, ma'am.
You're clear, and you're clear on what you're going to do.
Yes, ma'am.
And you're satisfied with what they've been able to share with you as far as where we've been going throughout this process. They've been accessible to you. You've been to court many times, correct?
Yes, ma'am.
And they've shared everything that they have with you.
Yes, ma'am.
Do you need any additional time with them this morning before we proceed?
No, ma'am.
Thank you, sir. You may step down. Next up.
The article will rest when the jury comes back.
The jury.
Judge, the jury's in the courtroom.
Good morning.
Good morning.
Ladies and gentlemen, it is Tuesday, September 30th, and what a week it has been, right? Let's get started. Mr. Massey, Ms. Fuchs.
Danielle, please, on behalf of the defense, the defense rests.
Does the state of Tennessee wish to present any rebuttal?
No, Your Honor.
Ladies and gentlemen, you have now heard all of the proof in the case. We're going to take a short break while I go over your instructions with the attorneys. I'm going to give them a few minutes to prepare their closing arguments, if any. The state may give a closing argument and the defense may give a closing argument. If the defense gives a closing argument, the state will be allowed to give a final rebuttal argument if it wishes. This is because the state has the burden of proof in this case. During this break, even though you have heard all of the proof, do not discuss the case amongst yourselves. It is now 10:26. I hope to be with you very soon, and I hope that we can work, the lawyers and I can work rather expeditiously so as to get you back in and go over these instructions. I'll see you in a minute.
Ladies and gentlemen, the jury, leave your pen and pad in your chair. Follow me.
Notice I didn't mention lunch yet. But I will. You may have a seat. I'm not certain if Ms. Harris sent out preliminaries. Did everyone have? She sends them out to everyone. You guys discuss. It's just been passed a request for lesser included offenses. Has the state had an opportunity to review what Mr. Massey has filed?
We are just receiving a copy, Judge.
It appears as count 1 and count 2, this litigation team for Mr. Isabelle is asking for second-degree murder, reckless homicide, and negligent homicide. As to count 3, first-degree felony murder, they are asking for second-degree murder, reckless homicide. As to count 4 of the indictment, aggravated child neglect, they're asking for child neglect. As to count 5, especially aggravated kidnapping, aggravating kidnapping, and kidnapping as lesser. I have thoughts, but I'd like to hear from the state.
Judge, we just reviewed the proposed lesser included, and we're in agreement with those to be charged to the jury.
Under State v. Burns, the court must determine whether any evidence exists that reasonable minds could accept as to the lesser included offense. Negligent homicide is not on the table for the court under count 1 and 2. Neither is reckless homicide under counts 1, 2, and 3. The court must view the evidence liberally in the light most favorable to the existence of the lesser included offenses without making any judgments on the credibility of such evidence. And then I must determine if the proof provided was legally sufficient to support a conviction for the lesser included offenses. This is a practical two-step analysis under State v. Burns. I'm happy to share it with you while I take a brief recess.
What's the brief recess?
Run back and forth.
We are still working our way through the instructions. I think that there was one page that we all agree there was a little phrase that needed to be taken out.
And I just gave her that, if there was abuse and there was neglect, and she's correcting that.
Okay, so if it is now 11:12, what time would you like me to revisit you? I understand this. How many pages do you have there?
24?
I understand you need to go through them, and I understand you want to go through them with Mr. Massey and with Mr. Isabelle. I'm not trying to rush you. I just need to know what I'm doing.
I would say, yeah, there. 20 minutes?
That's perfectly fine. I don't want you to feel as though I'm ignoring you and I'm not here. I'm here. You just let me know when you're ready.
And
We do, Judge, we have, and I think Mr. Steele and Ms. Carpenter can speak better on the law on this, but we do agree, all of us, I think, agree that reckless homicide and negligent homicide should be included as lesser included under the first-degree murder counts, and they've been looking at the case law, but I think we all agree that should be in there.
Your Honor, and...
Okay, so articulate for me what evidence supports reckless and negligent under first-degree murder, count 1 and 2?
I would, Your Honor, the state and I think defense would be asking for the inclusion of reckless homicide and negligent homicide, specifically looking at State v. Brown, which is a Supreme Court Tennessee decision from 2010.
Is that Benjamin Brown?
Yes, Your Honor.
Yes, I have it.
That case it's a somewhat factually similar, but it's a child abuse case. In that case, the child was shaken, reportedly, or that's what the jury found, and those were the injuries that led to the death. The charges include premeditated murder, I believe, murder in the perpetration of aggravated child abuse and aggravated child abuse. So the difference is abuse versus neglect, but generally factually somewhat similar. There, the Tennessee Supreme Court did go through, and it looked at Burns. It looked at State versus, is it Eli as well, and looked at the instructions that were given specifically by the court in that case were first-degree murder, stop. It wasn't second-degree murder, it wasn't criminally reckless or criminally negligent. The Supreme Court of Tennessee then looked at the mens rea requirement of knowingly under the facts that were in that case. And the Tennessee Supreme Court found that knowingly was fairly raised, and then went further and said, so second-degree murder should have been instructed. And then the court specifically then goes to, on page, I believe it is 433, I'm sorry, I have it highlighted, but I lost it. Oh, it's on 433, carrying over into 444. To quote the court, it says, it necessarily follows then that the trial court also erred in failing to instruct the jury as to the two remaining included offenses of reckless homicide, which is defined as, and he gives a statutory definition, and criminally negligent homicide. The court gave the statutory definition. The mens rea of recklessness and criminal negligence are encompassed by the definition of knowing, citing the State versus Eli. And therefore, having concluded the evidence would have supported a reasonable inference that the defendant knowingly killed Ashley, the victim in that case, we must necessarily conclude the evidence would have supported a reasonable inference that the defendant acted either recklessly or with criminal negligence. So basically, the Supreme Court of Tennessee said that if the mens rea requirement of knowingly is there, then these other ones fall under it as well. So out of an abundance of caution, Your Honor, because there's a level of review that we're to have, and the state would like to include those
Okay.
just to make sure that those are
You've noted it
covered.
for the record, fine,
Thank you.
add it.
Thank you.
Count 1, count 2, reckless and criminally negligent homicide?
And then for 3 as well, to also include reckless and criminal negligent homicide.
Okay.
Because it's the same
That's
intentional
what the state
number.
wants.
Yes, Your Honor.
And we all agree?
Yes, Your Honor.
Okay.
Going to count 5, out of the same, going out of the abundance of caution, false imprisonment, although it is lower down there, we are looking at the same reduction of the mens rea requirement. So the state would ask for that instruction to be included as well.
Okay,
Thank you, Your Honor.
add it. You agree?
We agree.
No one opposes what anything Mr. Steele just said?
No, Your Honor.
Well, let's go. But you still need 20 minutes.
Yeah, we're still reviewing over the rest of the language. Thank you.
Not a problem. Recess.
What's that, the recess?